Good afternoon. It's Lindsay from Freedom Media WA bringing you another live stream from here, Perth, Western Australia. And today's live stream is more debate, as I'll just bring up here. This is live from Parliament in Western Australia. And today there will be a continued debate on a motion that the Honourable Nick Goren has tabled, and that is to repeal essentially immediately would probably be the best way to describe it, the commitment that the Labor Cook government has given to repeal the Aboriginal Cultural Heritage Act. So I'm just keeping an ear, as I have done in the past. They're just going through the introductory preambles, and I'll just quickly make sure the stream is okay. To bring you up to speed, essentially, Thursday last week, Nick Goren tabled another motion because the one that the Honourable Neil Thompson tabled, not that it's actually been declared in Parliament, but in my view, my assessment of that is there was some particular type of wording that was that the government did not want to repeal or separate Part 2, which is the 2021 Aboriginal Cultural Heritage Act, from a 4-part bill. So that whether there was an error in that or a word, legal arguments are quite often focused around particular words, shall and may, for example. So it could be something as simple as that. So it seems that Nick Goren has redrafted the motion that Neil Thompson tabled and then reintroduced that on Thursday, late Thursday afternoon. Parliament, of course, doesn't sit late into the night, or didn't on that particular occasion, and it came up to some debate between Nick Goren and the Leader of the House, which is Labor Sue Ellery. That debate concluded quite quickly around 6 o'clock. The motion that Nick Goren has tabled is essentially about a quarter of the way through that. It ended with Nick Goren asking the question of the government that they please explain why they are not able to repeal, with the catchphrase that Nick Goren used, using the will of the people to repeal the Aboriginal Cultural Heritage Act. So I'm just going to cut through just to have a look. So we have Kyle McGuinness, who you can see on screen now, and I just want to cut through, excuse me for doing this, because I'm flying solo today. So I'm just making sure that the streams are going out okay. It looks all good from that viewpoint. A little bit of lag in terms of comments coming through, so I can't see any comments, but I can see that it appears to be okay. The person you just saw there, Kyle McGinn, is the Minister for Mining and Pastoral in the Legislative Council. I'm just going to okay, just more business there. Thank you, Sue. Welcome to the stream again. I can see the first comment to come through on YouTube. To those watching on YouTube, welcome. And this stream is also going out to Facebook and Rumble as well. I guess it's an important, it's particularly important to continue following up on this, because the government, as those that would have watched the previous streams live debate from Parliament last week that I brought to you, that the government made a very clear commitment that they got it wrong. That's the 2021 Act, and they would be repealing the Act. Essentially what we've seen is the government put pause on that, whether or not they may have been waiting for the outcome of the voice referendum. It's not particularly clear, but there is some, for the want of the better word, some skullduggery that a layman would quite adequately use in to describe the backflip or the blocking of the Aboriginal Cultural Heritage Act 2021 repeal. So I do want to, and I'm just going to just make sure that the audio on this is not going to come out and blast your ears there. So again, apologies for this. I'm just checking to make sure that the streams are okay, and it looks okay. I just want to take you back to Thursday's motion that Nick Goren brought up, and essentially the government, the Leader of the House, Sue Ellery, came back and brought up the argument that the Upper House have referred it to a special parliamentary committee to look at the bill, the 4-part bill that has been drafted by the government to look at amending the 1972 Act and repealing the 2021 Act. Now, Nick Goren quite rightly pointed out that on that particular occasion, Sue Ellery was relying on the fact that they need to wait until the parliamentary committee has had their sitting and until they give advice on that. And as I was about to say, Nick Goren did point out, and quite correctly, that the decision, the lawmakers, comes down to those that are the 36 members, as he said, that sit in the Legislative Council, and they are the ones that determine the legislative requirement or the law for the that gets either voted for or against, but that's where the debate occurs, and they are the lawmakers, the elected lawmakers, not some non-elected bureaucratic parliamentary committee that sits off to the side. So I'm just going to update on this here. In fact, while I'm just going to listen. Okay, I might just.
Members, that takes us to orders of the day. Leader of the House.
Thanks, President. I move without notice orders of the day numbers 1 to 7 be taken after order of the day number 8.
Members, the Leader has moved that motion, and the question is the motion be agreed. All those of that opinion say aye. To the contrary say no. The ayes have it. That takes us to order of the day 17, Aboriginal Heritage Legislation Amendment and Repeal Bill 2023, okay, so and we are in committee.
I'll just bring this up full screen. That will just give me a little bit of a breather just to make sure that behind the scenes that everything is all okay, and to make sure that you can get the audio. Of course, just in Parliament now, they've just killed their audio, so just no reason for concern on that. As soon as I hear it come back, I will cut forward. So as I was saying, the Honourable Nick Goren did highlight that the government is in essence, point 1, disregarding the will of the people of Western Australia and some 30,000 plus e-petition signatories, plus all the hundreds and hundreds and hundreds of WA farmers, primary producers from all different areas. The audio's just come back in.
Members, we are debating the Aboriginal Heritage Legislation Amendment and Repeal Bill 2023 in Committee of the Whole. I bring to members' attention the notice of the SNP 125 issue number 3, which will apply from clause 10, and the question is at clause 2 to stand as printed. Honourable Nick Goren.
Deputy Chair, when the bill was last considered by the Committee of the Whole House, we were considering in particular proposed provision 2B, found at page 2 of the bill. Deputy Chair, this is the provision dealing with the commencement, specifically dealing with the commencement clause for part 3 of the bill. And members will note there that part 3 of the bill, particularly division 1, will commence on the day after assent. Now, it's my expectation, Deputy Chair, that assent day could happen as soon as this week, and preferably so. And so part 3 of the bill, expressly division 1, will commence the day after assent. But curiously, part 2 of this bill, and part 2 of this bill is the provision that repeals the Aboriginal Cultural Heritage Act of 2021 and the regulations that have been made under that ill-fated act. That part, the repeal, the tearing up of that law, that will happen on a date in the fullness of time, specifically on a date fixed by proclamation by the government. Now, during the interrogation of this clause late last week, Deputy Chair, it became clear that the government say that this must happen by the 31st of December this year. Now, although the government say that it must happen at that particular point, this bill does not express the same thing. This bill allows it to happen on any day, including after the 31st of December 2023. Now, I asked the Leader of the House what would happen in the event that the government didn't do this by the 31st of December this year, and we were told, quite shockingly, that the outcome would be that on the 1st of January 2024, Western Australia would be left with none other than the Aboriginal Cultural Heritage Act of 2021. Now, this is the very act that has caused all of the problems and all of the concerns, and a record petition. So I think it's fair to say, Deputy Chair, that neither the government nor the opposition, nor any fair-minded Western Australian wants to see the Aboriginal Cultural Heritage Act of 2021 still in place on the 1st of January 2024. I mean, I know, Deputy Chair, that the Honourable Brad Pettit, for example, if I can say this, even he doesn't want that to happen. Now, he and I have a different view as to where this whole policy area should go, but I don't know of anyone who thinks that the Aboriginal Cultural Heritage Act of 2021, whether you're on the left of politics or the right of politics, that anyone thinks that this should be in place on the 1st of January 2024, and yet the government insists on having a clause here that allows that to happen. Now, the particular concern about that, Deputy Chair, is that if that were to occur, it would not even be possible for the government to make amendments to the 1972 Act, because as the Leader of the House drew to our attention late last week, the 1972 Act would not exist anymore. This is why the government say that this needs to all happen by the 31st of December 2023. And I did ask the Leader of the House to, during the adjournment period of the last few days, to give some consideration, or to ask the government to consider whether we could, at the very least, amend Clause 2 to make it expressly the case that Part 2 will come into effect no later than the 31st of December 2023. Now, I hasten to add, Deputy Chair, I'm not making a case for it to take that long. I think it's already taken too long. This should happen immediately, but the government is saying that they're not ready. That's the brutal reality here. Is after all of these weeks and months, the government are actually not even ready for the repeal to happen today. That's why it doesn't say that this will all happen on the day after assent. So the government is saying they need some time. My recollection is that the Leader of the House indicated that their anticipated timeline would be early November, was a date that they were working towards, but this clause doesn't say that. And so my question, Leader of the House, is has there been an opportunity to take any advice as to how we might be able to amend Clause 2 to better reflect the intention of government?
Minister.
Thanks, Chair. No, honourable member. Government is not of a mood to change the words. Now, I understand entirely the point you've made throughout the course of the contribution on this clause, which was quite extensive on Thursday afternoon. I reiterate the points that I made on Thursday, irrespective of the point that you make. It is in no one's interest that we do not proceed to take all the steps that need to be taken before the 31st of December. That's in nobody's interest, and we don't intend to do that. But for the reasons that I know you've found frustrating, and you expressed a view about Parliamentary Council, we're not able to make those changes, Honourable Member.
Honourable Nick Goran.
Well, Leader of the House, you can make those changes, but the government chooses not to make them. And with regard to Parliamentary Council and this notion last week that it's somehow some form of convention, I would draw to members' attention that a bill introduced by this government, or if we want to be perhaps technically correct, the McGowan Labor government, perhaps it could be considered to be the previous government, the Bail Amendment Bill of 2022, the commencement clause there is quite interesting. It reads, "This Act comes into operation as follows. A, Sections 1 and 2 on the day on which this Act receives the royal assent day. B, Sections 9 and 10 on the day after assent day. And C, the rest of the Act on the 28th day after assent day." Very specific. The rest of the Act is going to happen, that was the Bail Act, 28 days after assent. So there's no good reason why Parliamentary Council cannot assist the government in preparing a form of words to give effect to what the government say needs to happen. They say that it must happen by the 31st of December 2023, and yet that's not what's the case here. And so there is the possibility of, I don't think, Deputy Chair, charitably, that there is any intention whatsoever on the part of the Cook Labor government to delay this till the 1st of January 2024. I don't think that at all. So I don't think that there's something shifty going on the part of government. But, less charitably, there could be incompetence that occurs between now and the 1st of January 2024, and due to incompetence, we find ourselves in an entirely unsatisfactory situation on the 1st of January 2024, where we are left in Western Australia with the Aboriginal Cultural Heritage Act of 2021. And why will that be the case? Simply because the government refused to move a form of words now this afternoon, while there is this opportunity on the 17th of October 2023 to make sure that that definitely doesn't happen. No form of words provided by Parliamentary Council, no form of words sought by the government to make sure that this definitely doesn't happen. And in the meantime, we are expected, after everything that has occurred, to just trust them. That's effectively what we're being told this afternoon. Let's move off Clause 2 as quickly as possible so we can get to the Honourable Brad Pettit's amendments at Clause 10 and so forth. And in the meantime, we just trust the government that they're going to do the right thing. Now, this is a government who have proved in this particular policy area that they cannot be trusted. We were vilified by the Premier of Western Australia for raising concerns in June, and even when the Honourable Neil Thompson tabled a record e-petition, it was treated with contempt and arrogance by the Premier of Western Australia. And it wasn't until early August that reluctantly, begrudgingly, he had to come forward and say that he would repeal this law. And now we're the 17th of October 2023 and it still hasn't been repealed. And most Western Australians actually think this has already been done. And after all of that, we're being asked to just trust this government and just say, leave it with us, don't worry about it, we've got all under control. This will definitely happen by the 31st of December 2023. Well, who's going to make sure that that happens? Is it going to be Minister Booty? Is he the one who is responsible for making sure that this definitely happens by the 31st of December 2023? Well, you can't leave it to him. He's the guy who said everything was running smoothly. He was part of the cohort who said that there was no problems here. So now we're going to be leaving it to him. We're expected to just trust him because the government refused to move a few words at clause 2 to affect their intention. Minister, I've made the point. I know that you've heard the point. I know you understand the point. I know there's nothing further that you can reasonably do in these circumstances. My final question is, if a member moves an amendment to give effect to the government's intention, that is, that this definitely happens by the 31st of December 2023, will the government support that amendment?
Minister.
Thank you, Chair. No, honourable member, for the reasons that I've outlined extensively on Thursday afternoon and briefly today.
Members, the questions of clause 2 do stand as printed. All those of that opinion say aye. Aye. To the contrary, no. I believe the ayes have it. Can I have an indication, members? Members, the question is that clause 3 to 9 do stand as printed. You want to go to 8. The questions that clause 3 to 7 do stand as printed. All those of that opinion say aye. Aye. To the contrary, no. I believe the ayes have it. The questions.
Okay, well, there you have it. It sounded as though it was the end of that particular issue. The Honourable Nick Goren didn't call a division on that particular motion, but then he just stood up and said something there. I didn't quite catch what it was, so we'll just stay with it for a little bit more, but it seems as though it's done.
Minister.
Since it's a regulation-making power, honourable member, so arguably yes, it does contain Henry VIII provision.
Honourable Nick Goren.
And Minister, this House, as you're aware, has a long-standing view with respect to Henry VIII clauses. So what is the justification for their inclusion at this time?
Right, this is a good, interesting development. Just going to do a call out there. I can see Rob. Thank you very much, Rob, for your continued support. You know what that means. And yeah, just a little bit more debate. It seems that you've just seen the robust argument.
Minister.
Thanks, Chair. Now, this is not a new argument to the honourable member. Transitional regulation-making powers of a broad nature are not unique to this bill. A similar provision was included in Section 336 of the 21 Act. The broad transitional regulation-making power provisions in proposed Section 71 are tailored to the specific scenarios that might arise under this particular bill as we repeal the 21 Act and transition to the improved 72 Act. It allows any such transitional matters to be properly addressed as required. There may not be occasion to even rely upon some of the regulation-making powers, given the short period of time within which the 21 Act has been in effect. However, we cannot preclude that possibility, and so it's there to provide the opportunity if we need to.
Honourable Nick Goren.
Thanks, Deputy Chair. And so, Minister, it appears that one of the things that this clause does, clause 8, it allows for the continuation of the 2021 Act. You'll see this at proposed section 71, 3I, the continuation of the 2021 Act. But it also seems to give some opportunity for the 2021 Act to continue with specified modifications. What modifications do the government intend to make to the 2021 Act, which would be enforced during the transitional period?
So just why Sue Ellery, I guess, gets her advice there, you're just seeing that on the issue that Nick Goren, the back end of his motion, why the government won't repeal the Act now by a simple amendment, He's not taking no for an answer. Even though they voted on that, he's now reintroduced, I guess, that they're essentially debating the same thing. So there was a comment that just popped up saying that this is particularly concerning of what's actually going on here in the State Parliament in Perth, Western Australia. And I certainly...
Thanks, Chair. So
firstly,
the power to make transitional regulations is a power to deal with issues of a transitional nature or of a savings nature, insofar as they are necessary or convenient to support the transition from the 21 Act to the 72 Act. It does not authorise regulations which simply enable the provisions of the 2021 Act to be reenacted. The scope of the power has to be read in light of the fact that the purpose of the bill is to repeal the 2021 Act, and there is an express provision which does that. The regulation power cannot be read to override that repeal. The power is further limited to what is necessary or convenient for dealing with transitional matters, what will be considered transitional changes, and is limited with the passage of time. Now, I understand some examples were provided in briefings to members before we began the debate. So, in respect to paragraph I, it provides for the making of transitional regs which provide for the 2021 Act or a specified provision to continue as if the 2021 Act had not been repealed. There are examples of proposed regs, for example, the Aboriginal Heritage Transition Provision Regulations 2023 that are made pursuant to this paragraph. For example, Regulation 30, paragraph 4, provides that on and after repeal day, section 197(1) of the 2021 Act, which concerns other persons carrying out remediation if an order is contravened, continues to apply in relation to the contravention as if the 21 Act had not been repealed, and an authorisation may be given in relation to the contravention accordingly. Another example, Honourable Member, is Regulation 46, which provides that section 303(5) of the 2021 Act continues to apply on and after repeal day in relation to disclosures of information made before repeal day as if the 21 Act had not been repealed.
Honourable Nick Goran.
Leader of the House, it's my understanding that the proposed transitional regulations have already been drafted, and there has been some form of consultation that's been undertaken in respect to those draft transitional regulations. Is there a copy of the draft transitional regulations that is able to be provided to the House at this time? And is that one and the same as what will be the transitional regulations?
Just while Sue O'Leary again gets her brief, as Terry's just pointed out there, all he can see is those in the background on their mobile phones. Certainly, if you're looking at the pictures to the left of the House as the Labor government, that would be part of the 36 lawmakers in both sides of the House.
Advised consultation on those closed last week, Honourable Member. Feedback was provided, and that's been worked on now as to whether or not we need to change anything. So I'm not in a position to table a document. The consideration of that feedback hasn't been completed yet.
Honourable Nick Goran.
So the concern there, Minister, is that this provision at proposed section 71(3)(I) enables the government, without limiting subsection 2, transitional regulations may provide for the 2021 Act or a specified provision of the 2021 Act to continue to apply with or without specified modifications to or in relation to a specified matter or thing as if the 2021 Act had not been repealed. And there's a proposed draft transitional regulation in the public arena, but we don't know whether that's going to be the same as what will ultimately be the transitional regulation which includes the possibility of a very substantial Henry VIII power that's been provided here. I acknowledge what you have said, which is that consultation has concluded at the end of last week and it's currently being worked on. When are the... Is there some form of a time frame or a timeline that we're working towards here? I acknowledge that last week we said that we're working towards early November. Has anything happened over the course of the last few days or this consultation process that concluded on Friday that would change that timeline?
Okay, I'll just go again, just jump in quickly. Yep, those sitting on the back bench, well, they're just following orders. Innocent bystander, thank you very much for your comments there from Danistan. If you wouldn't mind just shooting a comment, where is Danistan? Tell us about that. And I'm just going to bring you up to speed here while we're talking about that. The Henry VIII clause is a clause within a bill that enables a minister to amend or repeal provisions
Chair.
of an Act of
Honourable
Parliament.
Member, I'm advised we're sticking with the same timeline. I tried to get an indication of the extent of the feedback and whether or not we were contemplating something, radically different to what had been proposed in the consultation draft. I'm advised no. There's no kind of substantive deviation. There might be some changes in language, but there's no substantive deviation.
Honourable Nick Goodall.
All right, well, thank you for at least providing that comfort. Minister, with regard to that same proposed subsection, that is 71(3), you'll see at 71(3)(c) that it's possible for transitional regulations to provide for the substitution of a specified person or body for any specified person or body as part of any proceedings. Why is this substitution regulatory power needed?
Okay, many comments saying they're not sure if Sue Ellery understands what she's reading. She's probably getting notes scribbled to her hastily, no doubt. Just coming back to the Henry VIII clause, in fact, what I might do is I will
Minister.
Thanks, Chair. So proposed section 71(3)(c) provides for the making of transitional regulations which provide for the substitution of a specified person or body for another specified person or body. We had in mind that the repeal of the 2021 Act would mean that certain bodies established under the Act would be abolished, and there may be a need for parties to proceedings to be substituted. For example, Regulation 31(2) provides for any proceedings under section 197(2) of the 21 Act to be continued or commenced by the Minister. This is in substitution for the Minister under the 2021 Act.
Honourable Nick Goodall.
And Minister, are there any such proceedings on foot at the moment?
Minister.
Thanks, Chair. No.
Honourable Nick Goodall.
All right, so it doesn't seem like it's really necessary. I could understand the necessity for it if there were proceedings on foot. So further to that, you'll see it's a proposed section 71(3)(d) that transitional regulations may provide for proceedings and remedies that may have been commenced by or available to or against a specified person or body to be commenced by or to be available to or against another specified person or body. I take it then that there are no such proceedings and remedies that are also on foot there?
Minister. Honourable Nick Goodall.
Right. Now, Minister, so again, I think that's 5 lines of the bill that could be struck out, given there's no necessity for it. That said, at proposed section 71(3)(e), it also provides for transitional regulations to provide for the transfer of or the creation of interests in specified property, rights or liabilities. Are there any limitations on this transfer power?
Okay, there's a bit of a pause there. I'm going to just bring you in a little bit of the Henry VIII clause up on screen. just need to get box 2.
Minister.
Thanks, Honourable Member. So not unlike the answer that I gave previously, we had in mind that the repeal of the 21 Act would mean certain bodies established under the Act would be abolished, and there may be a need for property and assets to be transferred to another person or entity.
Honourable Nick Goran.
So that was what was in mind, and there may be a need for it. So is that intended to occur?
No.
Minister.
No, Honourable Member.
Honourable Nick Goran.
Okay. I do wonder who gave the instruction to include these particular provisions if there is no need for it. I mean, it only frightens the horses to be telling Western Australians in a statute that we're giving government the possibility of having a regulation-making power to transfer property in the creation of interests and rights and liabilities, and then we say, well, actually, we're not intending to do anything like that. So why include it? Minister, 71, proposed section 71, subsection 3F, also provides for transitional regulations that may provide for the modification of specified agreements or other instruments. What agreements or instruments does the government intend to modify?
And just picking up on Rob's comment there on Facebook, the transfer of property and assets, like FK, you can join the dots on that one. But this is why I would suggest that sharing a stream like
Chair.
this...
So that provides for the making of transitional regs which provide for the modification of specified agreements or other instruments. An example of a transitional reg made pursuant to this paragraph is proposed Regulation 51. That regulation provides that if on or after repeal day a written law or document refers to the 2021 Act, the reference is taken, if the context permits, to be a reference to the 1972 Act.
Honourable Nick Goran.
Now, Minister, the following subclause provides for transitional regulations to provide for a specified person or body to take possession of books, documents or other records, however compiled or stored, that are or were in the possession of another specified person or body. Why is this power of seizure needed?
And as I was about to say, yeah, it's one of the importance of streams like this, because I guess if you touted in discussion that there was provisions under an act to transfer property and assets, then the Labor government no doubt would call it misinformation, as the federal government, Labor government, have done with the Voice. And you're hearing here in Parliament that Sue Ellery has outlined a section of the Act that gives that exact power. Nick Goran, through his robust questioning, has determined
so an example made
needed,
pursuant to this paragraph is proposed Regulation 48. The regulation provides that at the beginning of the repeal day, the records of the ACH Council become the records of the new ACH Committee, and on and after repeal day, the committee may hold, record, use or disclose the records for the purpose of or in connection with performing its functions. Now, I note the point that the honourable member has made. Bear in mind these are transitional provisions and had to be written not knowing what might happen between the 1st of July and when the legislation is repealed.
But the government's already committed to repealing the 2021 Act.
So thanks for that helpful explanation. So in terms of this power of seizure with regard to books, documents, records, etc., although the wording here is very broad, one might argue even unlimited, at this point in time it's only intended that it would apply to the Aboriginal Cultural Heritage Council.
Minister.
Member.
Honourable Nick Goran.
All right, and my last question in respect to this clause, Minister, is in respect to proposed section 71, subsection 3H. Now, this power for officers of the department to exercise powers under the Criminal Investigation Act of 2006, is this the retention of a long-standing power or is it a new one?
Exactly, Rob. Yep. We don't know if we're going to use it, but we'll put it in anyway. The government's committed to repealing it, but they're refusing to repeal
Minister.
and split
Thanks,
the bill
Chair.
to take out the 2021
It's new.
Act.
Examples of transitional regs made pursuant to this paragraph can be found in Part 10 of the regs, the Aboriginal Heritage Transitional Provisions Regs 23. For example, Regulation 36 provides that certain authorised officers are able to exercise a number of prescribed powers under the Criminal Investigation Act to investigate offences under the 21 Act committed before repeal date. So as I said, it's to capture that period between 1st of July and repeal day.
The Honourable Nick Goran.
So, Minister, under the 2021 Act, which is in force at the moment, do departmental officers have this power under the Criminal Investigation Act of 2006?
Just a quick comment there, picking up on Josh McCurry talking about that he might run in the next state election, but in particular his number one, vote no confidence. And it's debates like this that I can see.
Yeah, so I'm advised that specific powers were laid out, were prescribed in the 21 provisions, but a decision was made for, I suspect, I don't know, ease of reference, to refer to the same powers, but that are those that are within the Criminal Investigation Act 2006
And the decision was also made by the Labor
Minister,
government to
at the present
repeal the
time,
2021
a departmental
Act.
officer, a Western Australian departmental officer has, as I gather from you, limited powers under the Criminal Investigation Act of 2006, limited in the sense that there are some powers under that Act that they can exercise, but this would actually open the door for them to be able to exercise all powers under that Act?
I think there's no doubt, and hopefully it's coming across that way. In my view, I think the Honourable Nick Goren absolutely has the Leader of the House, Sue Ellery, and in particular the Labor government on the back foot over this, because he, using his vast knowledge as, with his legal training, and he's picking apart and pointing out the flaws in the government's own bill.
Leader of the House.
Chair, what I'm advised is that the decision was made to write it as it is in H, to use, if you like, a sort of standardised set of powers, as opposed to trying to rewrite something that was written specifically for another piece of legislation in the 21 Act.
The Honourable Nick Goran.
Minister, I can understand the simplicity of the form of words found here at lines 21, 22 and 23 at page 7 of the bill. But I want to make sure that we're clear as to what extra powers we're now going to be giving departmental officers to exercise during the transitional period. What are the powers that I'm less interested in the powers that the departmental officers have at the moment that will continue. But what are the ones that they don't currently have that they will then have as a result of this provision?
And again, just picking up, if that is the particular standard that the government's wanting to put in, then you would say that it's a superfluous argument, because on the 8th of October, Roger Cook, Tony Buddy came out and said to the public, publicly, with all their press conferences, that they got the 2021 Act wrong and they're going to repeal it. So it really makes it, I guess, I'm dumbfounded to really understand and see, as Nick Goren has been pushing the point here, that makes it glaringly obvious that the government has said they recognise that the WA people would understand that this actually has already been repealed when it hasn't, that it would be political suicide for them not to repeal it when there's an opportunity for them to do it, and they're not.
So the powers listed were identified as being largely of a kind provided for in the 2021 Act, noting, however, that Part 10, Divisions 3 and 5 of the 21 Act appear to confer broader powers on inspectors than would be available to public officers under the Criminal Investigations Act. This ensures that the authorised officers have sufficient powers to investigate offences allegedly committed under the 2021 Act in the transitional period, so before repeal day. Proposed Regulation 36 provides that an authorised officer is a public officer for the purposes of the Criminal Investigations Act and can exercise specified powers, namely the powers in Part 2 concerning ancillary provisions about exercising powers, the powers in Part 5 Division 1 concerning powers of entry and search with an occupier's consent, the powers in Section 33 concerning search powers in public open areas, the powers in Section 39 except subsection 1F concerning the power to search for things relevant to an offence in a vehicle, the powers in Part 5 Division 3 except sections 43(8)(b)(2) and 44(2)(f) and G4 concerning powers with a search warrant, the powers in Part 6 concerning obtaining business records, the powers in Part 7 concerning gaining access to data controlled by suspects, and the powers in Part 13 concerning seized things and related matters.
The Honourable Nick Goren.
So what you're reading from there, Minister, is that the proposed transitional regulations? Right, so that is what the government have, if you like, telegraphed is the intention of proposed section 71(3)(h), and that is that the draft that has been provided in the public arena does not allow officers of the department to have all of the suite of powers under the Criminal Investigation Act, only those ones that are listed there.
That's my suggestion, that's correct.
Okay. Now that list that then you've helpfully provided, which are in the draft regulations, noting it is the draft, is there any intention to change from the draft and the final?
By interjection, no. Honourable.
Okay. And the list that you've provided in the draft there, are any of those powers more expansive than what presently exists for a departmental officer?
Leader of the House.
I advise no, Honourable Member.
Okay. The question is that Clause 8 do stand as printed. All those of that opinion say aye. Aye. Those to the contrary, no. I think the ayes have it. The question is that Clause 9 do stand as printed. All those of that opinion say aye. Aye. Those to the contrary, no. I think the ayes have it. The question is that Clause 10 do stand as printed. The Honourable Dr Brad Pettit.
Okay, so these are so again, I mean, even that last particular part there, and I'm just going to make sure that I can just monitor what's going on in the background there. Again, as Rob has just highlighted, you know, when you hear concerning things like search powers, that the 1972 Aboriginal Cultural Heritage Act doesn't have that, nor does the 2021 Aboriginal Cultural Heritage Act has provisions for search powers, but they're seeking to A, repeal the 2021 Act, and B, beef up the 1972 Act to include provisions of search warrants to go into freehold land. And I guess a search warrant for that particular act would be to look for evidence. I mean, I don't know, don't quote me on this, but I can only surmise that perhaps a defence would be that you didn't know that the particular land had cultural significance or heritage significance. But if they can establish evidence to prove that you did in fact know, but you've declared that you didn't, and gained that evidence by using a search warrant, well then you're done and dusted. You know, you're going to be facing a criminal offence. So the language and things like that, search powers, in terms of, you know, that is a big stick approach, where the overall objective, which has bipartisan support, like the Voice, there was no doubt that that there was, you know, Australians want to close the gap. Australians want to preserve Aboriginal cultural heritage laws, But why does the government have to introduce such a big stick and looking at coming in with search warrant powers? Of course, you know, you can just see where stuff like this could eventually go. It starts off with a search warrant, which means you need a lawfully executed and heard and sworn search warrant, to things like the COVID management bill, where police have the power to go into your home, break down your front door, do all of that without a search warrant. So once things like a search warrant gets included into an act, then you can only see if that's the mindset of where the government have gone with particular bills. I am suggesting that it could potentially lead to an absolute weaponisation of provisions like this to be implemented using a search warrant today, and then they can enter a property, freehold property, whatever the title is on the property, without a search warrant tomorrow. And the robustness in which the government is refusing to repeal the 2021 Act would only give rise to concern, and that this could, I'm not saying it is, and I'm not saying that I've heard anything in this debate that has that would categorically lead me to believe that that is the direction or intent that this particular amendment or bill could go. But geez, I'll tell you what, you're going to take a hard-pressed conversation given on stuff that we've seen last year on the COVID amendment bill to convince me otherwise, that the government has a clear and particular mindset in the direction that they want to take this. There should be some immense concern with stuff like this, and hence the reason, as I was trying to say earlier, that people of Western Australia, which has actually, and I'll just bring her up now, the picture of Sue Ellery right here in parliamentary debate last week. She acknowledged herself that she understands that the people of Western Australia understand that the Aboriginal Cultural Heritage Act 2021 has already been repealed. So there is common ground in relation to that. She didn't refute the discussions that the opposition made on that. So the fact that this is a big dig in by the Labor government, in my view. And while the pastoralists and those that turned up on the steps on the 8th of August are not back on the steps of Parliament, has me somewhat perplexed. Look at it this way. The farmers turned up on the steps of Parliament on the 8th of August, which was a Tuesday. On Saturday night, come Sunday morning here in Perth, Western Australia, the Sunday Times had the news headline, which I did a post on that, saying that the Act, in fact, while I'm sort of talking, I might actually try and see if I can just bring that up and show you the headline that the Sunday Times put out. Now, it was my understanding in talking to those that they were looking at I'm not going to say organising a rally, but there was a lot of discussion around the amalgamating efforts of getting a number of pastoralists to travel vast distances to come to Parliament. The government put the headline out leaked it to the press on the Saturday, put the headline in the Sunday Times on the Sunday, and there was rumours that I heard that they were pushing on the Pastoral and Graziers Association and also the WA pastoralists to stop farmers protesting on the steps of Parliament on Tuesday, because optically it was a very, very bad look. Farmers went ahead on that Tuesday, the 8th of August, and we're still finding that sometime after, and just excuse me whilst I'm talking and looking down, I'll probably just bring you up, you in Parliament here. Okay, it's. I'm just trying to do a bit of a search here to see what I can find. Right, here we go. Why I bring it up a little bit differently. We want that one. And you can see there, of course, just on the side here, is my little addition to, sorry, not the Sunday Times, the West Australian. I apologise there. To the Sunday Times, of course, it would be the McGowan favoured mouthpiece rag for his Labor government, the West Australian. But this headline, which you can see here, came out on the Sunday. And then, of course, the 8th of August was the rally where farmers turned up there. Now, I guess that is the end of the particular motion and the purpose of this stream here. I guess I can see 56 minutes to go down. There's still a number of you watching, so thank you for that. I can actually, I guess, comment below. I do have so a little bit, I've got 2 packages that I can roll out for those that may be interested, and I'll put it back to you. If you want to see what actually happened, you've heard today, which is on the back end of the motion that Nick Goran brought on Thursday, and I have those particular debates, Sue Ellery and Nick Goran. They're not long, they're small packages. I've taken the most of it out. If you feel as though you might want to hear that, I'll just give a few moments for some comments to come through and then I'll play them. So in the meantime, I guess, what actions, if people of Western Australia, the government under the agreement that people of Western Australia understand that this Act has already been repealed, and on the back of not capitalising on the success of the voice, because there is no winners, I've said that before, but it was a very, very resounding result in Western Australia. It's nearing 64% no. Some of some of the most disadvantaged in remote communities in the northwest of Western Australia, it's nearing a 71% no. Is it time for people to find their local member of the Legislative Council, which is the parliament that you are seeing here, and then just write to them and say that there was a very strong public media belief created, or perception created, around Premier Roger Cook, Minister Tony Booty, that the 2021 Aboriginal Cultural Heritage Act had been repealed. And they are shocked and concerned to find out, you are shocked and concerned to find out in writing to your local member that this is not the case, and the government, you are aware, have opportunity to repeal this bill, but they're seeking to hold out if it's done by the 31st of December this year, as the Honourable Nick Goran said, and if it's not done in time for that, then essentially it will go on. There will be a large break over Christmas. You are commenting that you do want to see that. The packages. Let me just bring the audio up, make sure that I have the audio. Okay, so here's a short reply that I'm going to bring you now, and hopefully this will work. Otherwise, I'm going to have to duck behind the scenes just quickly, but it should work. This is Sue Ellery essentially being able to read Nick Goran's, and she's Nick Goran's mind. Let's have a look.
I reiterate the point that I've made before, Honourable Member, and I understand the point you're making that you're saying failure to put those extra words in leaves it open to a government to do the opposite of what this government has said we intend to do.
Yes.
I understand that's the point you're making. We've been back to Parliamentary Council to ask why was it specifically drafted in this way, and to ask the question that you've just asked. And the answer is, yeah, you're smiling because you already know what the answer is, and I know that what you're thinking about it.
So there we go, and I can see Kelly saying that she disagrees that Australian people saved our country, and I guess where I'm saying that there's no winners is the concept that that people, it was the model of the voice that, in my view, people actually opposed and spoke out to do no votes in my mind. But the concept of looking to, I guess, when there is an audit of funding that has gone through to a number of these, 1,100, I think, Warren Mundine has touted, Aboriginal corporations around Australia, the administration processes to ensure that the funding, when it comes in at the top end, actually gets through to the remote communities. I think conceptually most Australians want that, but the model that they saw with the voice was not going to deliver that. And I guess probably the prime example of that would be some of these charity organisations like, say, UNICEF, for example, you know, where if you look at their financial reports, even though they're non-for-profit, you can see that a lot of the money that comes in is quite heavily weighted towards exorbitant salaries of those in lucrative positions at the top and administration fees, and what actually gets filtered down to those that most people are making the donation for, they would find that in a dollar, you know, it's not even 50-50. In some cases, you know, 80% of it is taken up for administration costs, and only 20% gets through to make a difference. So, so here we go. I'm just going to bring you Nick Goren's response. This is Thursday last week. This is where the debate ended on Thursday, and that we've heard, of course, today. So this is Nick Goren last Thursday when he introduced the motion.
Honourable Nick Goren.
Look, the problem here, and this is not isolated to this bill, is that Parliamentary Council's office, with all due respect to them, they are not the lawmakers of Western Australia. The final lawmakers in Western Australia are the 36 people elected to this House. Now, if Parliamentary Council want to have a convention or a standard drafting practice, that's all well and good, and it is ordinarily a good and proper thing that they have that. But they are not the determiners of the law of Western Australia. If the government of Western Australia, currently the Cook Labor government, are saying that this absolutely must be done by the 31st of December 2023...
Honourable Nick Goren.
Look, the problem here, and this
my
is not
fault there. I think I've
bill,
just killed that, and we're starting from the beginning. I apologise for that. They are not the lawmakers of Western Australia. The final lawmakers in Western Australia are the 36 people elected to this House. Now, if Parliamentary Council want to have a convention or a standard drafting practice, that's all well and good, and it is ordinarily a good and proper thing that they have that. But they are not the determiners of the law of Western Australia. If the government of Western Australia, currently the Cook Labor government, are saying that this absolutely must be done by the 31st of December 2023, then it is not the place of Parliamentary Council's office to stand in the way of the government of Western Australia. It is not the place of Parliamentary Council's office to stand in the way of the will of people of Western Australia who actually want this thing repealed yesterday. The people of Western Australia don't even want to wait till the 31st of December 2023. So it's a wholly unsatisfactory situation that we find ourselves in here, that Clause 2 leaves it to the government of the day, currently the Cook Labor government, the possibility of never repealing this law. So now I'm just going to kill this here because I've got it on a different earpiece, and I think that is quite relevant, as Nick Goren just said on the end there, that the people of Western Australia don't want to wait until the 31st of December this year, because most people in Western Australia understand that this Act has already been repealed. So and there's many things that are coming through, and I guess just on the voice referendum, and I see the point that you're making there, Kelly, in relation to the bigger agenda. But I guess you know, a tree is not fallen with one axe chop, and you need to start somewhere. And I guess for me, the base point of this is you know, with so much going on at the moment, that we need to, you know, the people of Western Australia need to be pushing back on issues that the government have very clearly, in my view, come out and said that they will do. And that is, they said they will repeal this Act, and they're not doing it. Nick Goren has made a very sound argument that he's put forward and torn holes in the government's bill, and they haven't been able to provide a satisfactory reason other than they've referred it to a parliamentary committee, which you've just heard Nick Goren say, they are not the lawmakers. It is those people in the 36 elected seats of the Legislative Council. So change needs to start somewhere, pushback needs to start also, and emailing off your local member could be just a means of, that's a barometer. Like we've seen in the referendum, that the government were thinking that they were safe and home and hose and ignoring the polls when it came down to it, you know, that 60-40 or 61-39 across the nation. If some of these Labor backbenchers were all of a sudden to start receiving emails and airing in a diplomatic manner, that you know, their seats are in grave danger because they've demonstrated that they're not exercising the will of the West Australian people come next election, then that could speak volumes for how unsafe their seat may be. But they will only form that opinion when people express that opinion to them. Now, you may not get a reply. I get it. Over the last 2-3 years, there's been many people that have emailed campaigns and they've had no replies. But the fact is, it is very well noted when it goes that they're receiving those inboxes. I think I did a stream with Ralph Babbitt, and he said, you know, he definitely notices when people take up campaigns. I think on that night. Yeah, as David's just picking up then, I think that is quite important. And if I actually had commenced this stream at the beginning, you would have heard the preamble. They do the Lord's Prayer, which is interesting. There was no welcome to country today that I heard, so I'm not sure what to make of that, but that was something that I did note. But they do reaffirm the oath that they have been elected to do, and that is to serve the people of Western Australia. And as David was just saying then, just come back to that, that an elected member of Parliament is telling the Labor government, that's Nick Goren, that democracy is not decided within their party room. It's not so much the point Nick's making within the party room, it is by the non-elected bureaucrats in parliamentary committees that sit off to the side and brief the Labor Party. So he rightly pointed out, it's in the chamber, which you can see right here. These are the people that have the ability to approve law, if you like. So there we go. I'm just trying to sort of pick up there's three pages that comments are coming through, just seeing if there's anything else that I can come through. But I think on that note, you well and truly understand where it's at. My intention was really just to bring in the last of the debate of the motion that Nick Goren brought in, which essentially will split a 4-part bill into one, which will allow, as he said last week with a simple amendment, it would allow the government to repeal the 2021 Act this week. In fact, they could have done it last week and they haven't, and they've also, as you've heard, voted this week that they're not going to do that. So there we go, and an interesting weekend. I'm sure that many people would have been out if you didn't pre-poll early and vote on the referendum. There was some interesting things. Of course, there was the stream that I brought, the impromptu stream of Amber Jade Sanderson, which has gone nearly this morning on my end. I can see sometimes when people on Facebook, I talk about views and things like that. They say one thing, but I see another. So it does seem that Facebook doesn't quite want to show the same analytics. But that particular stream, as rough and ready as it was on the phone, is nearing 50,000 views, and the comments is nearing some 820 comments, which very clearly doesn't pass the pub test in relation to the standard that was set right there. In terms of trying to get the clear footage of there, the reason I wasn't able to do that is because I had people off to my side. I thought that somebody was going to, in fact, tip a can of Coke over my head. In relation to that, one of the Fruit Loop Brigade was there. I'm not sure, either a very, very unattractive woman or a man dressed as a woman. And I can tell you, in my view, it was the latter. And I was having them push and shove into my side, which made it a little bit difficult to get that view. But I did have quite a lengthy discussion with the AEC supervisor from that particular booth, and I did seek to make a formal complaint. Of course, there was also the incident of a person who was blocking, who was very capable of blocking the free path of one of the No campaigners who was handing out how to vote, and whether that person is making a complaint of assault to police, well, that's up to her to do that. But I did highlight the circumstances of what actually occurred to the AEC electoral booth operator. I am working on, of course, I have got the McGowan and his job, his 5 jobs. I have had to park that. I was completely shattered on Sunday because having spent Saturday very early in the day to late at night running around and looking to see what grabs I could do to bring you how things were on the lay of the land. But it was more a day of me getting out and having conversations with people. I will say, interestingly enough, for I guess historical reasons and also for self-information, I did have the opportunity to scrutineer. And whilst there are clear guidelines as to what I can and can't say about what I saw scrutineering, and that is that I can't reveal an individual's vote, which is quite clearly when they're tipped on the table, you can't do that. But there was a couple of things that I did see was quite interesting. Number one was the AEC supervisor of the booth that I was scrutineering, which was nearly 1,500 votes that came in. And a prick of a man. That's what I'm going to say. what a prick of a man he was. From the get-go, he did everything he could to make it near impossible to make sure that, that you could go in under the guidelines of the Australian Electoral Commission and fulfil your rights, lawful rights as a scrutineer. He did everything by trying to block that, that from happening. It took a number of phone calls to understand the position of where we were at. It wasn't until another electoral commission came into that particular booth. I was sitting in the foyer area. It was locked. I let her in. That was the only way she could have got into the building. And then when I had it categorically that the information by stopping me going in, because he said there was only one scrutineer allowed, when I had that, I raised it with him and the other AEC supervisor, and that was that his decision was overturned. But we also had, I can tell you my observations were, it was very clear that the number of people who voted in pen, and that I guess is telling as in relation to the level of confidence that the Australian people have with the electoral system, and something that the AEC really do need to try and take on board that issue. Not try, they should. They need to take on board that issue. We cannot have people who are exercising their roles as citizens under the democratic process going into these centres to vote with a lack of confidence from the moment they get out of their car to walk in and cast their vote. That was very, very evident. Just a few observations that I had there, yeah, there was, wasn't my intention to really talk about that so much now, but I think on that note there, thank you to those that have commented, and in particular the beginning or the essence of this stream was to talk about, see how that motion to repeal the 2021 bill went. So on that note, I think I'm going to sign off and say goodbye. Wherever you are, enjoy the rest of